Hers is different. She's brought. Nice.
This is fun.
Yeah.
Good for yeah, definitely.
Hey, how's it going? Good.
I don't know if you guys have met Sam before. Mostly on the legislative side. He does a lot of telecom work, so
Oh, great.
wanted to get him a little bit more up to speed. Sam's been a couple longer than I have, actually. Yeah.
I know. Is Bob gonna call in?
No, I don't think
Yeah, he knows how it works.
I know. Yeah. He's been around a while.
so. Or he's just never really had to learn. Yeah.
Okay. Good morning, everybody. My name is Nolan Moser. I am the Chief Administrative Law Judge here at the Oregon Public Utilities Commission. Thank you all for attending and participating in today's stakeholder training. I think we've got a great program for you. Excellent presentations on all aspects of what we do here in the Hearings Division, from basic participation in our dockets and monitoring of dockets to motion practice in contested cases. So we have 7 or so presentations. We'll have breaks throughout the next few hours. Strongly encourage questions. So for folks here in the room, we would ask that you hold questions till the end of each presentation, and then we'll go around and take them at that time. Folks online and participating via the webinar can type in questions, and we'll pull them up and ask them of presenters at the end of those presentations. Finally, at the end of the day, we're going to have Chair Decker come in and thank everybody for participating, and she'll also be available to answer your questions too. So let's kick things off. We're going to start with Diane Davis, who's going to give us a presentation about email lists and participating here at the Commission.
So good morning. I'm glad you're all here. And the first topic is, how do I know what's going on at the PUC? And people that have been around a long time know about our notification lists, but there are a lot of people who don't, and I answer this question a lot on the phone. So this is why we're starting here. We have what we call generic notification lists, and they're industry specific. So electric, gas, telephone, water. And then we have another set of lists for those same industries for rulemaking specifically, because that's required by the law. We also have a great notification list called Public Meeting Agenda. So if you're not in a place where you can get website access, but you can get your email, you can be on that list and still see what's coming up on the agenda, which is handy. So the question is, how do you get on the list? It's really easy. We have a group email in the Hearings Division Support Unit, puc.hearings@state.or.us. All you do is send us an email. We ask that you please send your complete contact information, because if we get a bounce back, we'd like another way to get hold of you to find out what's gone wrong with your email address. The other things we'd like to remind you is, Please let us know if your contact information changes. If you no longer want to get all that email, because it's a lot. We use the generic notification list to notify people of when a new application is filed or a new docket is opened. We use them to notify you of general PUC events that might not be related to a docketed matter or other important PUC information, like we now have a new utility program director. So they're good lists to be on, but they're only useful if you keep your information updated. Again, please send us an email. We also have subscriptions, and we offer subscriptions to our orders, to our notices of hearing, and we also have an administrative rule update. We do charge for these things, and the cost is set out in our rules, but orders are $100 per year, notices of hearing are $50 a year, and we send those out weekly. The administrative rule updates are $75 per year, and I try to do them quarterly. Doesn't always happen because of workload or because no new rules were adopted. The advantage to having the administrative rule updates is in the history section of the rule, I provide you the order numbers. And if you're trying to research the history of a rule, that does come in handy. But you can always call me and ask me. You can save yourself some money. Again, how do you sign up? Normally, I send out subscription letters to the current subscribers so they can renew. And this year, I'm planning to send out a subscription letter in the very near future to those generic notification lists that we talked about just a few minutes ago. You can respond to that, or you can just, again, send an email to the hearings group, and then we'll send you an invoice for the subscription. Once we receive payment, your subscription starts. Before I move on to move away and ask questions, I want to point out that we provided you with some additional handouts. That includes our newly adopted revised internal operating guidelines, our internal public meeting process and rulemaking process handouts. They go along with the internal operating guidelines, a sheet with docket designations, a little set of how to use e-dockets, and my favorite handout is filing requirements, so you know when you need to send copies, when you need a certificate of service, when you need to serve. And post-training, I plan to send you out the Division 1 rules, especially since we just adopted new rules about protective orders. And I'm going to send them to everybody who's here and everybody who's on webinar because I have all your email addresses. Questions? I sent them by email, and I have very limited copies here, but they're all attached to the email I sent out yesterday. And I'm going to find a way to post them in the webinar. I managed to get the presentation in, but not the handouts. Okay, back to Nolan.
All right. Thank you, Diane. Before we move on, I just want to ask, were there any questions from the webinar folks for Diane? No. Okay. Okay. I will have your attention for the next 50 minutes or so, potentially an hour, to go over a series of issues, categories of dockets, and structure here at the Commission. So we're going to cover rulemakings, contested cases, non-contested cases, and hybrid dockets, IRPs and RFP dockets. I'll go through each type of case, why we do what we do, and the way we do it, and how to get involved, and what to expect as a stakeholder. Throughout the presentation, I welcome questions. Just hold on to them, and we'll take them at the end. And if you're participating via the webinar, please type them in. Candace will compile them and make them available once we've completed the presentation. Okay, let's go to the next slide if we would. We'll start with the open meetings law. The open meeting law governs pretty much everything we do here at the Commission and is particularly important for rulemakings and the non-contested docket process. There are two main other types of cases here at the Commission: contested cases and hybrid cases, which we'll discuss in a little bit. But at its most basic level, the open meetings law requires that meetings of public bodies be open to the public, as strange as that sounds. So accordingly, this means that the Commission as a public body can only meet to deliberate or decide on matters in a public meeting. There are some exceptions to this rule, as we'll see in later slides. These meetings need to be noticed to the public in advance. So the public needs to know they're happening. They need to have an idea of what will be considered at the public meeting. And we provide that notice via we send out our agenda on our listservs, and we post our agenda on our website. In cases where the public meeting law applies, commissioners are typically acting in a quasi-legislative role, as opposed to a quasi-judicial or quasi-executive role. So the Commission, like a lot of other administrative agencies, is unique in that it's empowered by the legislature to embody these three roles. It's sort of the judicial, the legislative, and the executive all rolled into one. When the Commission makes rules and sets policies with its delegated power, it's acting in a quasi-legislative role. We'll talk about that role, and we'll talk about the quasi-judicial role today. I won't talk much about the executive role, but just so you know what that is, when the Commission issues licenses, for example, it's acting in a quasi-executive role. So whenever the Commission exercises its quasi-legislative role, it must do so in public, just as the legislature must do its business in public. And before we move off of this slide, I'm going to talk a little bit about our public meetings themselves. So a typical public meeting has the following elements. We start with a general public comment portion. We have a consent agenda, and we have a rulemaking agenda as well as a regular agenda. Because of the public meeting law's notice requirement, although a member of the public may speak in the beginning of a meeting about any issue, the Commission has to refrain from deliberation and decision on an issue that hasn't been noticed. So if a member of the public comes up to the Commission and brings out an issue they'd like to identify as a priority for the Commission, if it hasn't been noticed in the agenda, the Commissioners will listen, they'll be interested, but they won't engage with specific questions or comments on their own. So for these elements, the consent agenda is typically limited to those items that the Commission is considering that are fairly non-controversial and where we do not expect public comment or public controversy. The rulemaking agenda is limited to rulemaking items, not surprisingly. And then the regular agenda is pretty much everything else where we do expect comment from the public on those specific agenda items. So we'll begin with rulemakings in terms of our detailed discussion. And I'm going to spend a decent amount of time on rulemakings because there is some overlap in the rulemaking process and the non-contested or other than contested case process. So a lot of what we talk about here will be applicable in that next case process. So a rulemaking is defined as any agency directive, standard, regulation, or statement of general applicability that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of the agency. So as I said earlier, these rulemakings represent the exercise of the Commission's legislative powers. And through rules, the Commission implements legislative directives that come directly from the Oregon legislature, interprets legislation. So we often work with statutes that give us a lot of discretion and that are vague, and rules help interpret and implement that legislation. And this often results in new policy that the Commission makes. So it's pretty natural that a rulemaking process follows the same legislative processes that you would see at the Oregon State Legislature. So rules have the force of law, and parties before the Commission are required to follow them, and failure to follow our rules can result in penalties or fines. Ultimately, if rules are adopted, they will be reflected in Chapter 860 of the Oregon Administrative Code, which is devoted to rules associated with the PUC, and that's, of course, available on the Secretary of State's website. And the Secretary of State catalogs and manages the update of all rules. Let's move on to the next slide. Thank you. So internally, we've divided our rulemaking process into phases. And there's 3 phases: the initiation phase, the informal phase, and the formal phase of the rulemaking. So we'll begin with the initiation phase. In this phase of the rulemaking, the PUC works to determine if the rulemaking is necessary. And the PUC, the Commission, may always take up a rulemaking at its own discretion. But typically, rulemakings are driven by the following factors. The first and most prominent is legislation. So if we get new state or federal legislation, often it has a new requirement or a changed requirement on behalf of the Commission that we have to implement. And we'll instigate a rulemaking to address that. Another way in which we get to rulemakings is through investigations. So we may open an investigation to look at a policy question or an issue, and at the end of it, the Commission may determine that it's important to develop new rules to address a difficult policy question. And then just in general, changes to the regulatory environment. You know, a category here, transportation electrification. We've had some legislation that has dictated some new requirements for us, but also the environment is changing. Regulatory environment is changing around transportation electrification, and that's part of the genesis of our rulemakings there. So the vast majority of rulemakings that we undertake are commission-oriented, commission-initiated, meaning that we, staff typically, decides to initiate these rulemakings, or commissioners. But that's not always the case, and the public has a role here, and anyone may petition the Commission to open a rulemaking. If somebody does so, the Commission staff will typically, working with DOJ, will review that request and then make a formal recommendation to the Commission to open or not to open that rulemaking. And it does happen. So as an example, next week the Commission will be considering rules related to how energy service suppliers comply with Oregon's Renewable Energy Portfolio Standard. And these rules originated from a request for a declaratory judgment by a stakeholder. So they weren't initiated by staff or the Commission. Okay, let's move on to the next slide. So some of the things that you should expect in the initiation phase as a stakeholder. First, the first thing you'll see typically is a staff recommendation. So this is usually a report submitted to the Commission for review and consideration at a public meeting. This report is detailed. Staff works on it with their attorneys at the DOJ and will provide extensive background on legal and policy questions associated with that issue. And it'll include a recommendation to open or to not open the rulemaking. That report will be published ahead of the meeting, typically no later than Thursday before the meeting, but ideally on Tuesday. And it will provide some opportunity to offer written comment, and then you'll also have the opportunity to provide oral comment at the public meeting on that issue. And that comment can be provided over the phone or in person. So commissioners will hear from staff, they'll hear from the interested parties, and then they'll decide whether or not to open that rulemaking. And if the Commission decides to open the rulemaking, they may decide to make adjustments on the scope of the rulemaking. And that's something the Commission continually does at their various check-ins in the rulemaking process. So the Commission is always open to adjusting the scope of the rulemaking. So the next phase, and this is really where the rubber meets the road in most rulemakings, the informal phase, and this is a major part of the proceeding, and it's staff-led. So once the Commission decides to open the rulemaking, the docket is assigned an agency rulemaking number, an AR number, and staff drives this next process. Staff works very closely with stakeholders to come up with draft rules to present to the Commission, and staff uses a variety of techniques to lead this phase. Staff solicits comments, staff typically instigates a number of workshops, and then often staff will request that stakeholders provide and react to draft language. Staff is playing a lead role in this part of the process. Staff will ultimately propose rules before the commissioners. So commissioners may be engaged, they may be monitoring, but ultimately they're waiting for staff's recommendation. Additionally, an administrative law judge, and just for a little background, as chief administrative law judge, I manage the administrative law judges and assign them to specific dockets. For rulemakings, an ALJ may manage may monitor, the case during an informal phase during a rulemaking, and keep commissioners informed, but typically it doesn't play much of a role beyond that. So it's really a staff-led process, and ultimately, when this phase concludes, and it can be very extensive, so staff can have a very detailed and long informal process with lots of stakeholder conversations, lots of workshops, lots of drafts of rules, lots of comments. But when it all culminates, staff will prepare another report for the Commission, and this report contains the following information. So proposed rules with summaries, a summary of all the informal workshops and stakeholder comment, stakeholder engagement, and then a recommendation on whether or not to progress with the rulemaking to the final formal phase. And there's, as I said, there's ample opportunity for stakeholders to participate in rulemakings at all phases, including this final stage of the informal phase where staff presents its report to the Commission. So stakeholders will have the opportunity for written comment at that stage. They'll be able to come before the Commission when the Commission is deciding whether or not to open a formal rulemaking and provide comment. And that comment can be directed at anything really, staff's proposed rules, the overall scope of the rulemaking, and the Commission may take that into account when they make their decision. So if the Commission decides to open that formal phase, the Commission may change the scope of the rulemaking, may change specific aspects of the proposed rules or even rule language. And if the Commission does decide to move to a formal phase, then at that point a statement of need and fiscal impact is developed, and a great deal of information is filed with the Secretary of State. And we'll talk about that here in a second. So let's move to the next slide. Okay, so the formal phase, that is the next phase. So if the Commission decides to move past that informal section, we begin by publishing a notice in the Secretary of State's Oregon Bulletin, which includes copies of proposed rules. We also send proposed rules to key legislators. And then, of course, all the lists that Diane mentioned earlier. Those notices include the comment timeline, the hearing date, fiscal impact, and other key information. And this is more of a formal process, hence the name. So an ALJ leads the process and solicits comment from stakeholders as well as the public at a formal hearing. For some rulemakings, the formal phase may involve some workshops, including potentially commissioner workshops, but they're not required and they don't occur in every formal rulemaking. The hearing is a pretty significant event in the formal process, and it may and often is attended by the commissioners. And after a specific date, this is very important to note during a rulemaking, no more written comment is accepted. So it's very, very important to provide all the comment you think is necessary prior to that written date. And that written date doesn't necessarily correspond with the date that the commissioners review, deliberate, and make a decision on those rules. So you have to pay very close attention to that. Okay, let's move on to the next slide. Here it is. Rulemakings overall, what to expect. So just a sort of a final reminder what we talked about at the beginning, because rulemakings are commission actions subject to the public meetings law, decisions and deliberation must occur at a public meeting. So there are a few very limited exceptions to this. Principally, it's when the commission needs to hear specific litigation advice associated with a prospective rule. In that case, the commission may go into executive session to hear to discuss written advice prepared by commission counsel. So another important element to always expect: rulemakings are always accompanied by extensive public notice, plenty of opportunity for public comment, and as you just heard, at multiple times and in multiple forums throughout the process. Commissioners may not deliberate or decide on the rules outside of a public meeting. What that means effectively is that commissioners, unlike in a contested case process, which we'll talk about later, commissioners can't talk to each other or meet outside of a public meeting to deliberate on the rules. However, commissioners can individually and do talk to staff, talk to the Department of Justice, the assigned ALJ, and members of the public throughout the course of a rulemaking. So that's important to remember. And one thing that I think stakeholders sometimes forget is the commissioners can individually talk to stakeholders throughout a rulemaking. That changes when the comment period ends, but up until then, unlike a contested case, the commissioners can and sometimes do have individual conversations with stakeholders or stakeholder groups throughout a rulemaking. So let's move on to the next slide. So again, summarizing what you can expect and how you can participate in a rulemaking. In those early phases, you really work closely with staff. So strongly encourage participation in workshops, responding to staff solicited comments. Staff leads the process in those early phases, and that is where most of the hard work in a rulemaking gets done. So if you have limited resources, that is where to focus your resources and where to participate the most. And typically rules don't change that much after staff files their final proposals. So if you want to have an impact on rules, it's very important to engage with staff in that staff-led process. Rulemakings in general rely heavily on the initiative of the participants to be successful. So the rulemakings require proposals from stakeholders, content from stakeholders, and just in general ideas. You'll usually have the opportunity to influence and even propose red lines to draft rule language early in the process. This is typically an opportunity at all stages of the rulemaking, but as I said, it's most impactful earlier in the process. You can always expect to provide oral comment at a hearing, and that comment is provided directly to the ALJ, or in some circumstances, the commissioners if they are attending. And throughout, there's up until the comment deadline, there is wide opportunity to provide written and comment and argument. So, oh yeah, sure, go ahead.
Regarding workshops, is there like a quorum rule or a certain number of people have to be in the room for staff to say, all right, we can do this today?
Yeah, that's a great question. No, they don't. So the staff sort of holds workshops at its discretion, and And we strongly encourage aggressive participation on the part of stakeholders, but if stakeholders just aren't participating, then staff can move forward and propose rules. It's a good question, though. And then finally, you're going to have these public meetings, reports and rules that you can specifically react to up until the close of the public comment period. So rulemakings provide plenty of opportunity for public participation. Oh, yes, another question. That is correct. Yes, that fiscal impact must include an assessment of the impact on small business. Oh, I'm sorry. I was just counseled to repeat these questions out loud. So the first question was, during the fiscal impact, is that where the commission reviews the impact of rules on small business? And I said, yes, it is. The follow-up question was, is there any sort of methodology to assess that impact on behalf of small business? And the answer to that is there is no specific methodology. Typically what happens is the staff will use its analytical tools to assess whether or not there will be a fiscal impact, and that'll be described. But that is always made public and available to stakeholders. So if stakeholders disagree with it or contend that it wasn't accurately done, there is always an opportunity to provide input on that. And Diane will help here.
I want to chime in on that because I'm the agency rules coordinator, and I always encourage staff during their workshops to try to collect some of that fiscal impact information, because we like to repeat what the people participating in the workshops have to say about potential fiscal impact. So if people are attending the workshops and providing that input, we will include it.
Excellent, thank you. And sort of the dam is burst here, so if you have questions, feel free to raise your hand and let me know. And Candace, if we receive questions online, just interrupt me and repeat them to me, and I will answer them.
So far, I've been able to answer them.
Okay, great. Okay, great. So yeah, we'll change the format of my presentation a little bit. Feel free to interrupt me with questions throughout. Okay, let's move on to just summarizing the roles and rulemakings. Rulemakings are a little unique in that, unlike some other proceedings here at the Commission, the roles do change a bit throughout the proceeding, so it's worth noting. During the informal phase, staff is in the lead role. Staff and working with DOJ, staff convenes stakeholders, provides information, solicits input, and then develops proposals and rules. And then, so in this phase, you'll be working and commenting directly with staff. You'll be working through their language and providing input and proposals to them. During that period, the ALJ plays a pretty minor role. They really are assigned to the docket to monitor the process, potentially communicate with commissioners and keep them updated on what's going on. And then the ALJ may support staff as requested or answer some procedural questions, but it's really a pretty minor role. But during the formal phase, things reverse a bit. So the ALJ is really the lead in the process. The ALJ will be formally soliciting comment, will be managing the hearing. If there are workshops, leading the workshops, and then we'll be synthesizing the comments and recommending changes to the draft rules based on those comments to the commissioners. Staff does play a role in that period as well, but it's in support of the commission process to come up with final draft rules that the commissioners will consider.
We have a question
Oh,
from
sure.
the panel. Jordan Schoonover is asking, is staff required to include all interested participants in the informal phase workshops? How is workshop information disseminated to potentially interested parties?
Those are great questions. So I'm going to take a crack at it, but I'm also going to invite Diane to come up here and help with this one as well. So staff does have at least an informal obligation to ensure that every interested party participates or has the opportunity to participate during that informal phase. And there are a number of ways in which we try to accomplish that, and Diane will go through some of them with our listservs and things. So.
Again, it comes back to those notification lists. If you are interested in rulemaking, you need to be on the rulemaking notification list. When staff sends out its first workshop notice, I send it out to that industry notification list. I might even do it for the second one, depending on the scope and nature of the rulemaking. But by then, people should be on the service list for the rulemaking. It's up to people to become involved and engage.
And I will tell you that, I was once staff, and what I would actively, especially early on, actively reach out to constituencies that I thought would be interested in a particular rulemaking that I was working on. And of course, if you as a stakeholder express interest in a rulemaking, asked to be put on a list, asked to participate, staff will, and I think without fail does this, will put you on that list and will ensure that you're notified whenever there is any action in that rulemaking. That's a good question. Okay. Moving on to the next slide. So this is sort of the culmination of the process, decision making. So it all culminates in a public meeting. At that public meeting, commissioners are presented with draft rules by the assigned ALJ. This includes summary of comments and even sometimes a draft order for the commissioners to adopt, but not always. Sometimes that occurs. And then commissioners have a discussion on the bench. This is the first real opportunity for the commissioners to talk with each other about the rules and for them to hear and understand the individual views of the other commissioners. The only exception here might be if there was a workshop in this rulemaking where commissioners got a flavor for where each other were. So as part of this, they may review alternatives to the rules, discuss changes suggested by commenters, or propose their own changes. Typically, for complicated rulemakings, the assigned ALJ will guide the discussion of the commissioners, usually with an issue matrix of some sort, and we typically publish those along with the draft rules. Because these decisions must be made in public, they're occurring up on the bench, they've been noticed in an agenda, but often they occur after the public comment period has closed. So although you may go to the meeting and you may be witnessing and watching what's going on and may be very interested, typically the opportunity for public comment is over at that stage. Staff usually participates and is there and available to answer questions that the commissioners or the ALJ may have. So overall, that's a rulemaking. It's our most stakeholder-focused and stakeholder-driven proceeding that we have. And a good rulemaking is in most ways reliant on the quality and intensity of stakeholder participation for success. And we have a question. Yeah. Yeah. No. Yeah.
But I have two questions. One goes back to the open meetings law, just a brief questions that you have a consent agenda. Is there ever a time when something is on the consent agenda and then it's moved off of the consent agenda? And what is there an example of that, or was it happening to do that? And then maybe one step one of the
Sure, we'll start with there's two questions. We'll start with the first one. So it was regarding our agendas, and the question was, when we have something on the consent agenda, does it ever get moved off the consent agenda, and how does that happen, and are there any examples? And the answer is yes, that does happen. And typically what happens is staff will propose something for the consent agenda when staff considers it to be a fairly non-controversial issue. They have been working on it with stakeholders and they do not expect any comment for the commissioners on it. So they're making a prognostication that there won't be much public interest and that it's ready to be reviewed by the commissioners. Sometimes, however, a member of the public may come forward and say, look, I know this is on the consent agenda, but I really want to talk about it. I have a comment to offer, an insight, argument, et cetera. At that stage, we find that out at the very beginning of the public meeting when people are doing their talk slips. We will move that agenda item off the consent agenda and move it to the regular agenda. And so that individual will have the opportunity to make their comment to the commissioners, and then the commissioners will deliberate and decide on that agenda item. So you had another question?
You mentioned often that the rulemakings are under chapter 860. Is there another chapter that they do further that's much less common maybe?
Well, Chapter 860 in the OAR is devoted exclusively to the Public Utilities Commission. So that is where our rulemakings can be found, or our rules can be found, that is, once they're adopted. Diane will tell us about any other applicable rules.
So I'm also the rules coordinator for the Oregon Utility Notification Center, basically the call before you dig people. But they have their own process that they use through their public meetings. I just help guide them through the process and do the formal filings with the Secretary of State.
And I apologize, I did not repeat that question for the folks on the webinar. The question was, are rules always found in Chapter 860? Okay, so unless there are any other questions about rulemakings, we'll move on to non-contested cases. Non-contested cases are a bit of a different animal. We spent a lot of time on rulemakings, but the reason we did is because there's a little bit of overlap in terms of some of the procedures and restrictions, and they result in some decisions and decision-making procedures that are similar. There are many types of non-contested case dockets, and they probably represent the bulk of dockets we deal with here at the Commission. Investigation dockets, compliance dockets, reporting dockets are all part of this category. And these dockets, like rulemakings, are not subject to evidentiary rules, meaning that there are no formal rules of evidence which must be followed before the Commission may consider a piece of information. They are quasi-legislative, and again, as you will find in the legislature, anyone can present any content or information for the Commission to consider as part of these dockets. Often the commissioners or the Commission, that is, writ large, faces a choice when opening a docket in terms of how to treat it. If the docket does not involve the rights and privileges of an individual or an issue that must be addressed via strict evidence, the Commission has some options. So I'll just throw out an example. Say the Commission is considering sort of how to address in utility rates the costs associated with the new tax law. The Commission could open a rulemaking, creating new rules to require a certain treatment of this new tax law on behalf of utilities. It could open a contested case where testimony would be provided and evidentiary rules enforced to come up with a determination and an order guidance for utilities, or it could open a non-contested investigation. And the Commission might do that latter thing because the process is relatively flexible. It can be, not always, but it can be a quicker process than some of our other tools. And it can be a good tool when pure policy questions are at play. And then, like rulemaking, it is accessible to more stakeholders. So you don't have to have a lawyer to readily participate in a non-contested investigation. And just in general, it's a flexible tool. So we use it a lot here at the Commission. So we'll move on to the next slide and talk a little bit about the sequence of events and expectations. A non-contested case has a lot of the same features as a rulemaking, particularly the informal part. It's generally, although not always, staff-led. So staff convenes the stakeholders, develops the agendas, et cetera. Commissioners may participate in workshops or other key docket events. And there may be multiple reports back to the commission, check-ins at public meetings, et cetera, regarding stakeholder and participant progress in the investigation. These dockets typically culminate in a public meeting report and recommendation to the commission. Our reports are pretty detailed, as I'm sure you've seen. They describe legal issues, technical questions, stakeholder comment and input, and then they provide a final staff recommendation or a series of options for the commission to consider. The majority of decisions the commission makes are often a simple acceptance of staff's recommendations in a non-contested case, usually as part of a consent agenda. There may be a great deal of process in some of these non-contested cases, but in others there may be very little. It sort of depends on the issue and whether or not it is of great interest to a large number of stakeholders and whether or not staff considers additional process and outreach appropriate. Typically, for each public meeting, there are many non-contested docket consent items, and each with a detailed and thorough memo. And usually the commission adopts staff's recommendation unaltered. So stakeholders may participate in these dockets in two ways. First, through the staff-led effort that precedes the final recommendation to the commission. And then second, at or before the public meeting itself. So stakeholders may present written comments to the commission prior to the public meeting, oral comment at the public meeting. But stakeholders really do appreciate it when, the commissioners really do appreciate it when when you provide written comment at least 24 hours prior to the public meeting. So some words on roles and decision making, how to engage. So the roles in a non-contested or other than contested case are fairly similar to those in a rulemaking. Particularly in the informal phase. Staff leads the docket. ALJs provide some support, typically around arranging a schedule for the docket. Decisions must be made in public meetings, so the commissioners can talk about these dockets with staff, the ALJ, their advisors, and any stakeholder who's interested, but they must decide and deliberate in public. And you can participate in these dockets much the same way as you would in a rulemaking. So you can work with staff, stay engaged there, file comments, and participate in workshops, and then, of course, the public meetings. Just in summary, it's a very flexible process. It's largely how the commission does business for the majority of its dockets. And when a great deal of stakeholder engagement is called for, it's very much like the informal phase of a public meeting or of a rulemaking, that is. Yes.
So how, you mentioned that, that the commissioners can talk to staff, and I get that, on non-contested cases and to stakeholders. How often do, individual commissioners reach out to stakeholders to discuss the non-contested cases?
Yeah, that's a great question. So the question was, because commissioners can talk to staff, they can talk to stakeholders, how often do commissioners reach out to talk to stakeholders in the context of a non-contested or other than contested case? And I will say that it's relatively rare that the commission reaches out. When the commissioners have a specific question about a stakeholder position, they might do so, or they might do so through an advisor or through staff. That's principally the way it's done. But nothing prevents the commissioners from doing that. I think the practical issue is that the commissioners have a lot demanding their time. And so they don't spend a lot of time doing individual stakeholder outreach. But it does happen, and the commissioners do have stakeholder meetings and can have stakeholder meetings on non-contested issues. So, moving on to contested cases. So, contested cases are largely governed by the APA, or Administrative Procedures Act, and the Commission's procedural rules. And you can find those in Chapter 1, Section 1 of our rules. So, whereas rulemakings and non-contested cases are typically ways in which the Commission exercises its quasi-legislative power, contested cases are how the Commission exercises its quasi-judicial power. A contested case must be used where the rights and privileges of individuals are at stake. So this is typically where rules or standards, laws apply to individuals and are enforced on individuals. Because these are quasi-judicial processes, they're governed by trial-like procedures, and they're actively managed by an administrative law judge. These cases involve disputes over fact, law, policy, and decisions may only be made on the evidentiary record, which is a bit different than other categories of cases where decisions can be made on really any information received by the Commission. In these contested cases, ex parte restrictions apply to the decision-making team, and we'll talk a little bit about that later. That's an important area. And full participation in a contested case is really only available to you as a stakeholder where you're represented by counsel. Parties can participate without counsel, but there are restrictions there, and we'll talk a little bit about that later. Sometimes contested cases are used for policy questions, although this is relatively rare. Typically, this occurs when there is some need to collect and test evidence associated with a challenging policy question. So the contested case process is a tool for the Commission that they must use in certain circumstances, but they will use in others where they don't have to. So there may be certain circumstances where the Commission, to answer a challenging policy question, could go straight into a rulemaking, could have a non-contested investigation, but that does not prevent them from deciding that that's appropriate for a contested case. And sometimes they do, and sometimes parties advocate for that as a better mechanism. So in contested cases, due process rights must be upheld. So, if you've watched Law and Order or anything like that, you know what that means. That means your rights as an individual must be observed. You must have notice to the proceeding, fair opportunity to present your argument, your evidence, and the full opportunity to respond to evidence submitted and argument. So though the public meeting law does apply to contested cases, the commissioners can and do deliberate and decide on these cases in private. So they do those in decision meetings that are attended by senior staff of the commission, commission counsel, and in those meetings they review proposed orders and make decisions. Yes?
Can you clarify, when a meeting, and you might be getting to this, but when a meeting between commissioners is allowed and that's considered official and deliberative as opposed to they're allowed to talk informally and that's not considered?
That's a great question. So the question was, what's sort of the dividing line between when the commissioners can talk and meet and when they can't? So when is it a deliberative meeting in a contested case where they can get together to decide an issue, and when is it an improper conversation? And so the commissioners can get together, just in theory, anytime they want, as long as it's noticed as a public meeting. And they can get together and talk about issues associated with either a contested case or a non-contested case, as long as the public has notice of it. For contested cases only, the commissioners may deliberate in private, but that must be a specific deliberation to deliberate and decide. So they can't just meet to talk about the case and consider or gather evidence, for example. They can only meet in private to deliberate and decide. So if the commission wanted to, let's say, for example, hear from staff about the arguments of the parties as in the course of a contested case proceeding, they could not meet as a group and ask for staff to come provide that briefing and assessment of party arguments. They would have to do that in public via a hearing, allowing every other party the opportunity to present its view of the evidence. So they can only do it typically towards the end of a case when they are deliberating and moving towards a decision, final decision in the case. We have another question.
Related to that, is, so when the commission is going to have meeting with staff individually, commissioners, can they, and do they, one at a time meet with staff? And their informal meetings, and then constitute a deliberative meeting that is.
Yeah, so that's a great question. So the question was sort of when and how does the commission meet with staff in the context of contested cases? Do they do it, have series individual meetings with staff? And the answer is yes, that's typically the way it goes. There are individual meetings that's our common practice between staff and commissioners in the context of contested cases. However, and this is very important, those meetings do not occur with staff engaged in the case as witnesses. That would be an ex parte contact. So in the context of a contested case, we're going to get to this, but the commissioners, the decision-making group, cannot have individual conversations with parties. And staff is typically a party in contested cases. So if you're staff and you're a staff witness, you are prohibited from having an individual briefing meeting with a commissioner that is not part of a broader hearing or something where the other parties can participate. The exception is the advisory staff. So Oregon is unique in that we have senior staff that play a management role of line staff, but also an advisory role. And they're very careful about this, the dichotomy there. They may meet with commissioners individually in the context of a contested case to provide them non-biased, basic technical information associated with the contested case. And that does happen. However, recently, as many of you know, the commission has brought on commission advisors to play part of that role and to provide another independent voice within the commission office for those types of briefings. Yes, a follow-up question.
Who decides that it's unbiased?
Yeah. That's a great question. Who decides that the information is unbiased? Well, I would encourage you to review our internal operating guidelines, which clearly lay out sort of what senior staff can and should talk about in those conversations, and clearly disclose sort of how that happens. But I can tell you, having been in countless of those conversations, that staff acts extremely professionally. And whenever there are very rare circumstances where we occasionally have an ex parte contact, those are appropriately noticed. So, all right. So continuing on with the due process requirement. Sort of as we get closer to decision, when we get in those decision meetings, the assigned administrative law judge works with commissioners on the development of a final written order, which is deliberated and considered by the commissioners at those decision meetings. And that order must make findings of fact and law. So on the types of cases and sequence of events, I'll first go through the sequence of events, and feel free to ask questions here because there's a lot of steps. So the first major step in a contested case is the pre-hearing conference. And at the pre-hearing conference, the ALJ will bring all the parties together, confirm party status. So before you can engage in a contested case, you must request intervention and become a party to that case. Typically at or shortly after the pre-hearing conference, the administrative law judge will grant intervention. The pre-hearing conference is an opportunity to review the procedural schedule. So the key dates for the proceeding, when testimony is due, when briefing is due, the hearing date, whether or not there'll be oral argument, when the commission may issue a decision. All that happens at the pre-hearing conference and is considered at the pre-hearing conference. Typically, following the pre-hearing conference, parties work on and then submit testimony. So testimony ranges, but it's typically submitted by a party using an internal or outside expert to provide factual evidence on the key issues in the case. Later on in the process, we typically have a hearing. Now, the hearings are sometimes waived, so the parties can argue that a hearing is not necessary and may request that it be waived. But a hearing is a courtroom-like proceeding with the presiding ALJ, although sometimes the commissioners participate and preside as well, where evidence is presented by the parties, where witnesses may be cross-examined, and questions may be asked of witnesses. Following the hearing and the close of the evidentiary period, we have briefing. So briefing is where the parties make both a legal and factual argument to the commission. And they do so in a serial format. One party will go first, or a series of parties, and then they'll be followed by another. And that sequence varies depending on the case and the schedule. If necessary, or if requested by the parties or the commission, there may be an oral argument. And an oral argument is an event only for the lawyers, fortunately or unfortunately. And that means that all parties represented by counsel have the opportunity to provide their assessment of the case from a legal perspective to the commission in an oral argument. Typically begins with opening statements, back and forth between the parties, questions from the commission. And commissioners recently have been finding that a pretty useful tool in contested cases. Your oral argument is typically the final official event in the schedule, though not always. And then after that, the commission deliberates and decides. So develops an order and then works as a unit to decide on that order. The types of cases where the contested case procedure is used are pretty wide-ranging. So everything from complaint cases, so where an individual customer is complaining about a utility issue and issues a formal complaint, rate cases, some tariffs, and then some complicated investigations, as we discussed earlier, which might require a rigorous evidentiary record. Next, we'll just talk briefly about the Commission's roles in a contested case. So a contested case is driven by the ALJ and the Commissioners. Although the ALJ and the Commissioners generally defer to the parties on questions of schedule procedure where parties agree. Where they don't, that's when the ALJ or the Commission will step in and make rulings, which can then be appealed to the Commission if parties are dissatisfied with them. Typically, staff acts as a party in contested cases, and senior staff provide advice to the decision team as the decision team has questions. So as you know, we deal with many complicated technical questions here at the Commission. And the commissioners need access to staff expertise, and staff provides that expertise. And again, I would encourage you to take a look at our internal operating guidelines, which have recently been updated, to get more information on sort of how that works. We also have commission advisors that play both a technical advisory and policy advisory role here at the Commission. So moving on to sort of the practical ways to engage. And so, one thing to note is that a lawyer counsel is necessary to participate in all aspects. So really, you could hire a lawyer. but you can participate in a contested case without an attorney. For an authorized representative of a group may participate in a contested case. They may provide policy argument. They may provide testimony on factual issues or technical issues, but they are prohibited from providing any legal argument. That's important to note. So there is that part of the case that that folks will not be able to participate in unless they have a lawyer. In some cases, there's a very narrow circumstance in which individuals in complaint cases may provide some limited argument, legal argument, but that, again, is pretty limited and pretty unique to cases where you have a complaint case and someone is representing themselves. And they may only do so with sort of guidance and support of the presiding judge. One other way to get involved in contested cases if you don't have an attorney is to work with staff. There are some limited opportunities to work with staff as part of contested cases to sort of make your voice heard. That is an option. Okay, moving on to ex parte contact. We touched on this a little bit earlier. So what is ex parte contact? So it is any off the record, meaning not in a hearing or not in a published document that's part of the docket, communication between a party and any member of the decision-making group during the course of a contested case. And we don't, ex parte contacts aren't technically prohibited, but we always notice them and we discourage them on fairness grounds. So ex parte restrictions exist to ensure fairness. And the idea here is that all parties should have equal opportunity to supply evidence and argument to decision makers, and all parties should have equal opportunity to rebut that evidence and argument. So when you have an ex parte contact, you're having a situation where a party is having unique access to a decision maker. And that means that other parties aren't hearing about it, they aren't seeing it, they aren't having an opportunity to rebut that statement or those arguments. And just real quick, the folks who are subject to the ex parte contact rule are any employees in the decision-making group structure, and that includes the commissioners, the assigned ALJ, so the ALJ assigned to that specific case, any assigned commission advisor, and then occasionally we will assign staff as a commission advisor for a case. This happens pretty rarely, but it does occasionally happen. If that does happen, that staff member is subject to that ex parte rule. And so internally, what this means is that what we watch out for as a group, as a team at the PUC, is we make sure that any staff member who sponsors testimony or is working intimately in the case is not making ex parte contact with a decision-making group member. Same thing with the Assistant Attorney General assigned to represent staff in that case. So any contact, all contacts are not ex parte. So if a staff witness says hello to a commissioner in the hall, that is not an ex parte contact. That contact has to be, or similarly, if you're a stakeholder and you're a witness in a case and you have a conversation with a commissioner not related to the case, that is not ex parte contact. But any communication relating to the merits of an issue in the proceeding is an ex parte contact. And that can include any legal question, any policy question, any factual question. And these restrictions apply to all parties. So what happens if such contact occurs? Well, first and most importantly, all parties have especially the attorneys representing parties have a responsibility, a duty to report an ex parte communication if you think one has occurred. You can notify the administrative law judge assigned to the case in that event. You can also notify me as the chief administrative law judge. And then a final fail-safe is Mike Grant, the executive director of the agency. So if we find that an ex parte communication has occurred, that communication will be noticed in full in the record. So what does that mean? Well, that means if it's an inadvertent email, you'll see the email in the record. It'll be put in the record by the judge or by myself. If it's a communication that we find out occurred, verbal communication, the verbal communication will be relayed in narrative form. All parties in the docket will have the opportunity to respond to that ex parte communication and provide any, argument or evidence associated with it. Yeah, we do have a question.
Hi, we have a couple good questions before we move on to hybrid cases. Loretta Mappington is asking, is staff always a party to contested cases? If yes, why?
Great question. Staff is not always a party to contested cases. So, although staff doesn't have to go through the formal process of intervening, there are some contested cases where staff doesn't participate. These are typically complaint cases. So, we have a lot of complaints here at the commission between developers of electricity generation projects and utilities. In most of those cases, if not all of them, I believe, staff is not a party. Meaning, and that frees staff up for for a role as an advisory supporter to the commission on those cases.
Okay. And the second question is from Angela Crowley. Is there ever a point at which it is too late in a proceeding to request intervener status?
That's a good question. There is never a point where it's too late. However, the intervention status might not be granted because it is late. That can be a factor in a judge deciding not to grant intervention status. So we would encourage folks to try to intervene in contested cases as early as possible if they are interested in the case.
Just to add to that, I've often seen when the ALJ does the schedule at the Prehearing Conference, a lot of times there's a date for filing intervener status.
Yeah, that's correct. So Rebecca Brown at PG pointed out that ALJs do. Did I get your name wrong?
No, I'm with Northwest Natural now.
Oh, Northwest Natural. Okay. Well, I didn't get your name wrong, so I get some credit. So Rebecca pointed out that that often the ALJ, and this is true, will as part of the pre-hearing conference memo, create a deadline for interventions in a case. Now that deadline is not 100% firm. The ALJ can waive that deadline at their discretion, just as the ALJ can waive any procedural rule at their discretion. But the deadline exists for a reason. So there is a goal to try to get interventions in as early as possible, so parties know the contours of the case and can participate in forming those early on. Any other questions from online?
Yes,
Oh,
I have one on the panel.
okay.
Do you need to have a lawyer to ask for intervener status?
No, you do not need to have a lawyer to ask for intervener status. We have the best way to do that is to review our procedural rules. There are filing requirements associated with an intervener request in those rules. They can be followed by an organization. And we have another question. And you don't need to have any formality with me, so certainly not today.
I wanted to clarify, I don't think we've used the word intervener in this room today yet, so I wanted to make sure, correct me if I'm wrong, but are we going to talk about that more later?
Yeah, that's a good question. So why don't I take some time to talk about it now? I think I talked about party status earlier. And party status, the word party or the word parties and the word intervener is really only applicable in contested cases. In all other cases, at least for me, I typically refer to participants as stakeholders rather than as parties, because party status is a specific thing that you get as an intervener if you are granted intervener status by an ALJ in a contested case. So this is only as part of a contested case. So in order to have the full range of participation in a contested case, you have to request intervention. And if the ALJ grants that intervention, you are intervened, you are a party to the case. So that only applies to contested cases and hybrid cases, which we'll get to in a second. So it's pretty narrow. So when you hear someone talk about party, if they're using the term accurately, they're really only talking about a contested case.
I have a great question online about ex parte communication
Sure.
from Jim Creeder. It says, since we're talking about ex parte communication in contested cases, what are the guidelines in non-contested cases? From slide 21 in the non-contested slide, it says commissioners may hear from all stakeholders and review any material as a basis for their decision. Does that mean stakeholders or interveners can communicate with the commissioners? If they can it be written or by phone?
Technically, yes. However, and this is really important for folks to understand, the commission is very careful about that sort of contact. You can imagine in the context of, let's say, I was involved in LC 66, PG's IRP a few years ago. We had literally thousands of people interested in that case, in that docket, wanting to address and work with commissioners. Just by the sheer volume, the commissioners decided in that case to manage their contact with the public very carefully. And that is the commissioner's right and prerogative to do so. So the commissioners, although they can talk to just about anybody in the context of a non-contested or other than contested case, will often create restrictions around that just to be able to handle the volume and treat everybody fairly. That's the other thing. So if the commissioners decide, for example, in the context of an IRP, that after a certain date they're not going to meet with stakeholders individually, or that they're just not going to meet with stakeholders overall, one, there's a reason for it. You typically, around commissioner time and energy, just not having the time to do all of that in the midst of, because they have a lot of responsibility. And second, if they do decide to do that, they apply that very judiciously and fairly. So you will never have a situation where the commissioners in a non-contested case or an IRP decide, oh, well, we're going to sit down with the utility or this intervener that participates all the time, but not members of the public. So you can be assured that the commissioners will, whatever they decide to do for an individual case, they will treat everyone the same. Okay, any other questions? Yes.
Can you elaborate a tiny bit on, to clarify, you do not need an attorney to be granted intervener status, but you do need an attorney to participate in all aspects of a contested case. And then it goes on to say some participation possible without legal counsel. So what is,
Sure.
what's the for full participation?
Yeah, that's a great question. So the question was, I have a slide earlier that says you can participate in a contested case without an attorney, but you can't participate in all aspects of the case. And the parts of the case which you're walled off from are any legal argument. So the commission will not allow you to, or will not accept, any legal argument from a non-lawyer. And that's pretty standard practice across any court in the country. So the idea there is, if you do want to participate in all aspects, there are almost always legal issues involved in a contested case. You should get an attorney. However, if you just want to make policy arguments or you have key factual points to make, you can participate without an attorney. Okay. My final slide, final part of my discussion today has to do with hybrid cases. So these are cases in which we've got some elements of the contested case process and other elements of the non-contested case process. So we really have two categories of cases that are quote unquote a hybrid. And those are utility resource planning cases, or IRP, integrated resource planning cases, and RFP dockets. So we have planning dockets for our major utilities. These are significant cases. Utilities are requesting acknowledgement of a series of investments and actions. It is very important for the utility for later rate making treatment, and these cases outline the utility's plan to meet customer needs over a series of years. They attract a lot of attention, media attention, a lot of attention from stakeholders. They're universally considered very important. They also involve a lot of data, a lot of information. And so to manage that data in part and to manage the stakeholders that want to participate, we do not require, but we do request that parties intervene in these cases. And we do that for a couple reasons. It helps us track the people interested in the case, and it also helps us manage discovery and protected information, because in these planning cases and in RFP dockets, request for proposal dockets, there's a lot of protected information that is commercially sensitive, information that a utility may want to protect. And so it's a lot easier for us as a unit to ensure that information is protected if folks seek formal intervener status. However, these are not technically contested cases. The Commission is not determining individual rights, duties, or privileges. They're reviewing a plan. So they're hybrid cases, and that means that the Commission is deciding these cases in a public meeting. So if you've ever participated in a utility resource planning case or an RFP docket, you'll notice that when it comes to decision time, that decision occurs at a public meeting. The commissioners, just like they would in a rulemaking or a non-contested case, really get to talk with each other the first time about the key issues in the case up on the dais. And because these cases are so complicated and sometimes controversial, the commissioners may need a lot of structure around that conversation. So they may need, we mentioned earlier, the idea of matrices that a judge might produce for them and help them with the decision-making process. They may need that. They may need staff support in terms of technical questions, or DOJ support in terms of legal questions. And they may need a lot of time to do that. So often in these decisions, we will have a deliberation session, a comment session. It might be a multi-day process to get to a final decision. And once that final decision is made, the Administrative Hearings Division works to reflect that final commission decision in a written order. So these are pretty consequential cases. Accordingly, we use this hybrid model. We do that because we could do them as contested cases, but we want to ensure that there is that broad public participation, that it's accessible to everybody, that these cases, that stakeholders can easily participate in them and have an impact on these cases. And so that's why we have this hybrid model. And my voice is starting to go, which I guess is a good sign, because that was technically my last slide. If anybody, does anybody have any final questions before I finish up? Yeah.
So the regular agenda contains non-contested cases and hybrid cases, is that right?
That is correct. So the question was, what does the regular agenda include? Does it include non-contested cases and hybrid types of cases? And that is correct. They're decisions that have to be made at a public meeting, and they are. I've been here a few years. I have not seen a contested case go into a public meeting for decision. That does not mean it could not. There's nothing preventing the commission from deciding a contested case in public. They have the right to do so in a deliberation meeting, but they could, in theory, do it in a public meeting, but they don't. So you're exactly right. The cases that you'll see in a public meeting, on a public meeting agenda, are rulemaking cases, which are non-contested investigations, and these hybrid cases. So, all right. Any other final questions? Okay. Well, I think it's about time for a break. So let's all take a break. We'll take 5 minutes, and then we'll come back for more exciting content. Thank you all. Well, that's because everybody asked them.
Okay, you ready? Sure. Okay.
Look on time.
We actually covered some fun stuff, so. Some kids.
Do you want to help with questions?
I told him why he asked him. I said, hey, does he get up? I'm like, he's deep now, man. I mean, I think if anything, all my presentation does is outline quality. I mean, I'm going to go for nuts and bolts. Protective orders, you know, and those are straight out of rules, which are strictly here. So, I think that's the big thing is, hey, read the rules before you find something after you somebody
Read the rules. Presentation doesn't.
well, yeah, it's funny though that you say that because so I went to I remember it was some kind of building conference in New York City, and you know they were talking about how to install these very complicated but very efficient heating units. And the first picture that this one guy showed was a guy sitting on an upside down bucket going through the manual. He said, now this is something you don't see often. You know, and he talked about how important it was to read about the product that you were working with. And then he showed all these examples where putting, you know, shit backwards, or incompletely, in a way that, you know, you spend extra money to buy an efficient heating unit, and they're, you know, super efficient, and then you don't do the thing.
It is true. I bought a chainsaw recently, and I was so excited to use it. I almost didn't do that, and it was really close. I mean, I would have just ruined it on the first thing. I started reading, and I was like, oh, I would have put this oil in there because it just looked like that's where it goes, but that wasn't it. The first time you have to do it, you have to put a motor on it. So, you know, I wouldn't have done that.
Why in the world did you buy a chainsaw?
Okay. It was really cheap. You know, I have some like George Bush. I got some bush clearing I got to do in the back. You know. Yeah, on my ranch, my frame ranch.
No, I'm just kidding. I buy tools all the time.
It was so
You know, and it's like,
yeah, you keep them in your living room.
yeah, that's true. Actually, they've been booted out. But you know what's amazing? I have used them actually quite a bit.
Yeah.
Yeah.
Okay.
Yeah, this is my oldest got married. This time will be 3 years ago. Yeah, I even have a little 3-year-old granddaughter. Wow. Yeah. This is my oldest, and this is my youngest. She's in college. Yeah. So yeah, she's down there over here in Monmouth, and so I told her I was going down to today, and Really nice. I'll be here. We'll be just having some lunch. I know. Oh, good. So actually, I had somebody asking, so that's when I was texting somebody, and Mike could have asked that to me. She wants to log in, so I sent her another email with that webinar, and I'm like, if this doesn't work, break on that. So she'll still be able to do it? I don't know.
Are you ready?
It sounded like she was at work.
Okay, we wrote my own name.
Hi, I'm so-and-so. I'll be doing your button pushing, so.
Okay.
There's always a last minute person.
I'm
You
sure.
always do.
Well, I'm gonna try real hard. Do a really good job for you. So you don't have to say next slide. If you're on your slides and you're talking, I should be able to pick up when you're going to your next slide. But if I don't, just let me know.
Okay.
All right, you can do the old next slide. Okay.
I'll just run.
Okay. Make me proud. And be considerate of the time.
Hi.
It's gonna be hard.
Well, Nolan actually went over much stuff.
That's what Allison did. Chris presented on. I said, same thing Nolan was.
It's got a trickle down.
I just laughed.
Yes.
I said, I'm sure it's
Oh,
something
thank you,
else.
I tried.
Now.
Thank you for coming in.
Yeah, no, it's not
You
even.
got a good crowd. It's really exciting. I've been coming in a lot today. Yeah.
Sitting next
I have to meet you too.
Oh! Yeah. Thank you, thank you. I know, I've been here about 8 years, and you've been here a long time.
Or almost 4.
Yeah, how's Shannon?
She's not in our section.
Yeah.
Still with one class a little bit.
Yeah, I know she moved to a different department.
We see her sometimes. She's really trying her job there.
Okay. Yeah, so, I know.
And then our former boss are.
I know. Exactly. Did you see him? Okay. Yeah, I think, come in at the end.
You don't really need to. Okay.
What happens if you start calling?
That, but
Tell if you see my.
People, this room should clear.
I would, okay, we'll tell hi. Yes, I sure will. I'm so glad you guys came down and
Yeah, nice to meet you.
you too, finally. I know, huh?
I'm only doing this so you can knock it over.
I know I did.
If you get winded out, you'll find out who's sitting beside you.
That's exactly what it is. That is the safe word.
I'm gonna tell everyone we're gonna get started.
Ready? Okay.
Okay, everyone, we're about to get started here again with our next presentation. If everyone can take their seats, please. Thank you.
I was going to sit up there with you, just in case. Oh, great. Good. Where do you go? All right, well, good morning, everybody. My name is Chris Allwine, and I'm one of the newer administrative law judges here. I'm from Ohio, which is not California. And so in Ohio, I practiced before the Public Utilities Commission of Ohio as a residential advocate, an advocate for environmental groups, and I did some small utility compliance work. So I've gone from the PUCO to the OPUC. So I'm going to talk about protective orders, public meeting comments, motion practice, and petitions to intervene. I know Nolan already answered some questions about those, so I will skip appropriately. Also, just to make sure that any historical perspective is provided, I have Alan Arlo up here with me, who is also an ALJ, which I am glad that he's here.
One of the oldest, or the oldest.
It keeps Diane from sitting next to me. Just kidding. All right. So I just want to say, so I'm going to talk about protective orders, and so just to, for fun, I looked up what a protective order is on the Googles, and the first thing that came up was about a Yankee baseball player who got a restraining order against a crazed fan whose long-running obsession with the slugger landed in the Bronx Supreme Court. And I won't go into the salacious details, but I thought it was interesting because, they interchanged restraining order with protective order, and then the protective order essentially was granted because of the possibility of injury. And so how does that relate to what we do here? There are some, you can go to, let's see, oh, thank you. All right, there are some similarities because here, folks, primarily the originator of the case will ask for a protective order, not to protect, physical injury, but to protect from economic injury. And so, as you can see, it's initiated by a request, a motion from a party. A motion is a request. We'll go over that shortly. And what they're asking for is protection. They're asking for limiting the disclosure of certain information that may be relative to the case, but relevant, but the moving party considers it confidential. All right. All right. So what is confidential information? That simply is, here is the definition from one of the Oregon statutes. Trade secrets are confidential information, and those are anything that derives independent economic value, actual or potential, from not being generally known to the public or to other persons who can obtain economic value from its disclosure or use. And it also must be the subject of efforts that are reasonable to maintain its secrecy. And so examples of this are drawings, cost data, customer lists, formulas, patterns, compilations, programs, devices, procedures, methods, or techniques. And it's not exclusive to those, but those are some of the examples. If we go to slide 5, you've got that here we have a recent example, and I highlighted some of the items that the, in this case, Frontier Communications and Northwest Fiber were trying to protect. So they filed a motion and they asked for a protective order. And what were they trying to protect? They're trying to protect trade secrets, the financing of the transaction, revenues that were going to be discussed, technical details of their plans, and so on. All right. Because I think this is something about commission consideration here, but of course other parties intervened. Citizens Utility Board was a party to the case, and staff was a party to the case, and there was another trade association was a party to the case. And so all of those folks were potentially going to be reviewing this information that Northwest and Frontier wanted to make sure was confidential. And they usually get that information through a discovery request, which I believe Nolan covered. So in slide 6, so we've got here. So in slide 6, we're talking about a general protective order. This is very common. Here, I've got a recent example here. Basically is a process for parties to avoid discovery disputes, but still allow for broad discovery. And in this case, Idaho Power requested a general protective order in its annual power cost update. And they noted that the types of information they were trying to protect were certain work papers related to the filing of material that may contain confidential material. And they said, and I quote here, including but not limited to proprietary cost data and models, commercially sensitive load and resource projections, confidential market analysis and business projections, and confidential information regarding contracts for the purchase or sale of electric power and power services. And they note that the public disclosure of this information would be detrimental to, in other words, cause harm to Idaho Power and its customers. And so they basically filed a general motion, a request for a general protective order. All right. And so let's see. So the other type of order, I'm sorry, skip one. Okay. I won't read all the slides here, but a modified protective order is kind of like a, you can think of it as a general protective order, but with an exclamation point. Hey, this information is really confidential, it's very proprietary, and we want another level of protection. And so there are also, as I put up here on the slide, additional requirements, and those include the parties need to talk about exactly what they're trying to protect, the legal basis for the protection, which goes back to the trade secret statute, and what they want exactly to happen. So I've only been involved in a few cases with modified protective orders, but those included degrees or intensity of protection. So in one of the ones I did recently, it was there was a general protective order for some information, and then there was a highly confidential degree for certain information that would be limited as to who could look at it. And so that's basically how you can think of a modified protective order. Now, all the things I have in the slides here are just generally a part of our rules. So if you're going to do a filing like this for a protective order or a modified protective order, I recommend, and I'll repeat this probably a few times, but you want to look at the rule and make sure that your request, your motion, not only meets general motion requirements, but then meets the requirement for the type of protective order that you're going to file.
Well, it may be that almost all of you are aware of these general protective orders. I think one of the things that we should talk about, the reason it's called a general protective order is that it's a set plan, a set series of words that have been worked through many times by the commission, so that when you come and you ask for a general protective order, it doesn't have to be drafted from the beginning. We have to have the right words put in artfully, but you will know this is a particular form that has been used and that you can rely upon without having to parse the particular language of the general protective order to make sure that it will adequately be able to stand up to scrutiny before the commission, because it is one that is universally accepted by everybody who practices before us as encompassing those values and things which they need.
Yeah, and I would also add, too, that just because somebody is asking for information to be protected, the commission is not necessarily acknowledging that the information should be protected, but that would be up to a party to contest that, hey, they're trying to make this information confidential, but I think it should be public. So we're not deciding that the information is confidential here. We're providing, as Al said, either general protection or we're providing modified protection, which, unlike a general protective order, as Al described, a modified protective order is usually filed by the parties. But again, the information itself is subject to the scrutiny of the parties in a case. All right. Okay, does anybody have any other questions on protective orders? I know I kind of went over that quick. Go ahead.
Bill, you may cover this later, but I was curious if a party does contest information that the company is saying is protected, but they don't think it is, who handles that contest?
Well, the ALJ, who is
Your Honor,
Based-
please repeat the question.
oh, sorry, excuse me. So the question was if a party does want to contest the information as not being confidential, who handles that? So a party would likely file a motion, a request to the commission that the information should be publicly available, that it shouldn't be handled as confidential information, and of course there would be a response by the party that asked for the information to be confidential. We're going to go over motion practice here in a minute, but that is likely how it would be handled. Somebody would say, here are the reasons I think this information should be public. The entity requesting protection would likely talk in greater detail, and in fact, parts of these filings might be considered confidential if they're going to talk about the information specifically. So it would be redacted on the order until the judge decided whether or not, yes, this should be public, or no, it shouldn't be.
I have a question from the webinar from Angela Crowley, and she's stating that since the Idaho Power example seems very broad, her question is, does a general protective order mean that other parties cannot see any of that information?
No. That's a good question. What happens is when a general protective order or a modified protective order is issued, parties who would like access to the information usually sign a non-disclosure form that is a part of the agreement, and that non-disclosure form basically identifies who specifically will look at the information and what entity or party they are working with or for. A lot of times parties will have consultants, technical experts, and so they're not necessarily an employee of whatever organization it might be, but they are working with that party. So it identifies who it is and what information, that they'll be looking at the confidential information.
I think one of the other questions that sometimes comes up is to whether or not the person who is seeking to see the confidential information and who is willing to sign the general protective order is somebody who is appropriate to receive that information. For example, if there is sensitive marketing data, the people who may be involved in the case, the attorney and perhaps an economist who is working on behalf of the party, will be able to see the information. But there will probably be some pushback if it's the director of marketing for the corporation who is not involved in the particular issue but would sure like to get their hands on the particular data that their competitor has, would like to sign that general protective order. And generally there will be some argument or discussion as to whether or not the recipient's needs are relevant to the conduct of the case.
And just one last item on protective orders. There won't be any discovery if you request in discovery material from a party until the protective order is issued by the administrative law judge who considers whether or not to issue the protective order. No discovery would be had on that confidential information. and just other limitations with those greater degrees of confidentiality, you may be required, the person who's going to look at it for your organization may be required to go somewhere where this information is physically kept. I had a case in Ohio where I had to go to another law firm's basically conference room, and they had boxes and boxes of information that they did not want to copy or scan and send out over the internet, which was really fun because you kind of get to see how the other half lives, and they had some weird stuff in their bathroom. It looked like some of the attorneys lived there, but anyway, I digress. Okay, any other questions on protective orders or modified protective orders? All right, and again, I cited to the rules in the slides, and it's just really important. Nolan and I were just talking about how he bought a chainsaw, and he was almost tempted not to read the manual, but I think you have to read the rule all the way through, make your pleading, and then check it again. And that's the best way to do that. And we'll talk about that a little more here in a minute. So if there are no other questions, I'll go ahead and move on to public meetings, and specifically, I want to talk about comments for public meetings. I know Nolan already covered public meetings generally. I put down what the law there is, and of course you can attend our meetings in person via telephone, and you can also watch them online. As Nolan already talked about, for the first 15 minutes usually of every meeting, someone can come in and talk about something that they want to present to the commission that isn't on the docket already, and the commission will not engage, but they're very good about taking in comments from folks during that time. But the comments that I wanted to talk about were, we get a lot of comments for the rulemaking agenda and some of our regular agenda items. And for those, you can, the option there is providing something in writing to the commission. And I have actually an example here, and I just want to emphasize one item in there, and that is that, and these are also online. All of these are online, and there's always the same information in here. And I think the one thing that we need to emphasize is that, let's see, where's it here? Here it is. So when you file written comments, you likely want not only the ALJ, but you want the commissioners to be able to see the comments that you filed. But if you file them after noon the day before the meeting, it is unlikely, because as Nolan pointed out earlier, the commissioners are very busy. So it's unlikely they'll be able to really read and digest your comments. So that's just, if you don't remember anything else about filing written comments, make sure you file them at least noon or earlier the day before the meeting. Does anybody else have any questions about the comments? Again, all the rules, if you will, governing comments are on every public meeting notice that is on our website. Yes?
And so general public can file written comments on what kind of case, like without being an official intervener?
Yes, you can, anybody can file comments with.
Please repeat the
sorry,
question.
sorry, thank you. Sorry, Candace. So the question was, can anybody file comments on a case or an agenda item? And this commission, as with most commissions in the United States, prefer a broad as possible outlook on or opinion spectrum. And so I think, yes, even if you're not a an official intervener to the case, you can file comments for the commission to consider. In a recent case, we had and this was an IRP case, so not a contested case, but we had the U.S. Endowment for Forest and other sustainable initiatives file comments. And they weren't necessarily, well, you don't have to be a party to an IRP, but they filed comments on a particular issue for the commission's consideration. Is that correct? Anything to add there?
Can I add to that?
Sure.
There will be instances where there's a property sale and the people around the property may oppose the sale, and the general public will issue written comments to the commission in situations like that.
All right. Any other questions on public meetings? Any other comments? All right. Okay, we're going to talk about motions. And motions are simply a pleading employed by parties, and they're putting a request in front of the court. It's a procedural device in law, and it is meant usually to bring a limited but contested issue before a court, or in our case, administrative court, for a decision. It's not always contested. And of course, it's not exclusive to the Public Utility Commission. Motions are made at any point, not only here, but in other administrative, criminal, and civil proceedings. What are examples? Most of the time, people want to change the schedule, or they would like additional information to file something, or they want to strike information or testimony that they don't feel is relevant, or for some other reason, things like that. And so if we go to, let's see, slide 12 here. So again, this is all straight out of the rules, but the motion must be made in writing. It's got to conform with the requirements of a pleading and the requirements of the rule there that covers motions. And if it's a procedural motion, if I want to change the schedule and there are half a dozen other parties, it's not really fair for me to file something and say, hey, can you push this back a week? If you want a procedural change, you're required to call up all the other parties and say, hey, do you mind if we change this procedural schedule? And so unlike a substantive motion, which is likely contested, where perhaps you're trying to strike testimony, here you're trying to change the schedule, so you want to make sure it's okay with all the other parties before you do. And whether it's okay or not, as a part of your procedural motion, you do need to let us know what the other parties said. Because, and we'll get to it in a minute, sometimes people want these motions made in a hurry, and you're essentially cutting off the other party's ability to respond. And here, depending on what you're asking for, it could be prejudicial to the other parties. So let's see. And you can see there are specific rules here, specific timelines. So if I file a motion, somebody who wants to respond to my motion has 10 days to file it after I file my motion. So basically what you're doing is you're kind of arguing about something potentially back and forth on a piece of paper. I ask for something, another party or parties respond and say, hey, I like that, or I don't like that. And then if you go to the next slide, we've got replies. This is another reason you want to read the rules here, is you've got a party can file a response. So if it's substantive, they have 15 days. And if it is procedural, they only have 7. So if somebody files a procedural motion, you don't want to think you have 15 days, you're going to be 8 days too late. So if you go to the next slide.
I have a question.
Sure.
From the webinar. If you're not in a contested case, do you have to have a lawyer to make a motion, or can anyone make one?
That's a good question.
Anybody can make a motion. It doesn't have to do with a matter of analyzing or interpreting the law. So for example, if you want to provide some information, but it's going to take you a while to get it, you can file a motion and say, we need an extension of time of 2 weeks so that I can get this information and submit it to the commission. And I don't want to be considered out of time or disqualified in offering that information because it's coming in late. So that one of the advantages of an administrative proceeding is the fact that there is a certain level of flexibility that exceeds what may ordinarily occur in courts of general jurisdiction. And so that is an advantage. You have an expectation and understanding that you're dealing with rational and understanding people who will do their best to accommodate those who do not have access to an attorney. This is often the case, for example, in complaints where you have a customer who has a complaint against a utility with respect to their bill. And so the amounts of money involved are either very small, or the utility customer is not in a position to be able to hire an attorney at the rate of hundreds of dollars per hour to take care of a matter, which at best they can probably get maybe a few $1,000s at most if everything is settled exactly the way they wish. So that you're allowed to represent your rights, but you cannot make legal arguments. And that's really only a very small part of what would ordinarily be, for example, in a consumer complaint.
Thank you, Al. Got it. Okay. All right. And just one other thing here, the difference between procedural and substantive, again, is substantive. I'm probably asking for something that another party is going to contest, strike testimony or something like that. Procedural is, hey, I want to change the schedule that was set out a few months ago because I need more time. And that's the reason for the difference. You may ask for something to be expedited. Expedited simply means, hey, I'm in a hurry. Maybe something's due tomorrow, but I need another few days. And again, when you ask for expedited, you've got to basically confer with all of the other parties and let us know what the other parties said, because you're eliminating their ability to file a response. Any other questions on motions? All right, anything?
Well, I will give one example where you are required by our rules to consult with another party before you file a substantive motion. And that occurs during the discovery process, where a party may file a motion to compel, saying that we need this information, it's relevant to the case, and the other party refuses to produce it. Under those circumstances, you must make a representation under our rules that stated, I've tried to get that information and our negotiations have broken down, and that's why I'm coming to the commission for this relief.
That's a good example. Yes.
Whether there's a specific difference under the rules, like if it says petition, make sure you write petition, or if you're experiencing confusion between people using petition and filing a motion.
Well, I think this is one of those circumstances where we don't
Repeat the question, please,
Okay.
Judge Arlen.
The question is whether or not there are specific standards for filing a petition as opposed to a motion, whether one must properly identify a petition as opposed to a motion. Generally, petitions, at least in my experience, and I haven't cross-checked this with the rules recently, but when a person is initially becoming involved in a proceeding, or making an initial request of the commission for the first time to begin a process, that is when the word petition is used. And then once when one is inside the process and that's been initiated, then the phrase motion is used. But I think the most important thing to realize is that the idea of specific pleadings and having to say the exact right words is not something upon which a person's rights are going to turn in a proceeding before the commission.
And I would say that if you use the term petition, but you meant motion, it will be considered by the ALJ as a motion. That's usually what happens. People file something, and as Al said, maybe their words aren't exactly correct, but it's interpreted for what it is,
Right.
depending on the rest of the pleading. All right, the last thing we want to talk about is petitions to intervene. And basically, these are requests. You're saying I or my client or my organization have an interest in this case or proceeding. There are specific items that you need to include in a petition to intervene. Again, as Nolan already covered, you can have an attorney or a non-attorney representative. You can represent yourself, but that does engender some limitations on your participation depending on what the case is. Just to point out that the Citizens Utility Board basically is the consumer representative here in Oregon, so they have a statutory right to intervene in these cases. And we have sample petitions to intervene for folks who aren't used to writing a document like that. A declaratory ruling, you just need to file something additional that is stating that you agree with the facts that are in question and the statement of the questions as they're presented. Somebody can object to your petition to intervene, and it's treated the same way that a motion is in that respect. So it starts out as a petition to intervene, but you are basically filing a response where you think the party shouldn't be in the case for some reason. Nolan talked about a party being late. And does anybody have any specific questions on petitions to intervene? Yes.
Are there levels of intervention? In other words, can maybe a party participate but not be allowed to send data requests, or that they may just be involved to
There are the ALJ, depending on your petition and your stated interest, can provide or put limitations on your participation.
And you can ask to be,
depending on the circumstances.
you can ask to participate as an interested person, in which you will get copies of all of the pleadings that were filed, but you will not get copies of any confidential information, and you won't be entitled for example, to file motions or to make requests of your own with respect to the schedule. But just as an interested person, you are kept up to date with everything that's public. And that will automatically be sent to you.
Yes.
The question was, can you have a different level of intervention?
Sorry about that. Yes. Thanks.
My bad.
Thanks, Candace.
Respectfully, just wanted to clarify, my understanding is that actually the Citizens Utility Board represents residential.
Customers, right. Did I say something else? Sorry if I did. I'm sorry, you're right. Residential consumers, yes. That's a good clarification. The clarification was the Citizens Utility Board represents residential consumers of utilities.
Yes.
All right, if there are no other questions, thank you. And just remember, you want to read the rule, write your pleading, check it with the rule again. Like the old joke goes, a rabbit, a minister, and a priest walked into a bar, and the rabbit looked at the other two and said, I might be a typo. Okay. All right.
So I woke up at 3:30 this morning and said, oh no, I have to talk about e-dockets. Because if any of you have called me and said, Diane, can you help me find something in e-dockets? I usually have a long pause before I answer, sure, let's see what we can find. What you see in the public-facing version of e-dockets is not what I see in my internal-facing dockets application. So sometimes I get lost in e-dockets, which is kind of scary for all of you. So how do you get there? The link for e-dockets, this is how I would tell you if you were calling me on the phone. It's under the jars that are labeled on our main page. I also talk about when people want public meeting agenda, I tell them to look for the ladybugs. It's just the way I work. So I'm not going to go through everything you can do in e-dockets today. I want to make that clear up front. With your information, there's also a handout about some other searches and information you can find in e-dockets. One thing that went away fairly recently when we had our website redesign, we discovered that the Google type search in e-dockets didn't work anymore at all. So we took it away. People are missing it. We understand that. Call us. We'll try to help you find what you're looking for. You can find a variety of things, though, that are useful. We're going to the next slide. One of the things I need to point out, because I forget about it, if you're looking for a specific report that the commission published or a form, and we call some strange things forms, but utility companies often have to make filings on forms. They're available from the home page. Along the top navigation bar, there's a reports and forms button. Use that and search that. That's where the utility statistic books are found. To me, that's not a form, it's a book. So I had trouble with that at first. But if you can't find something that used to be on the website, look there. That's my big hint. And now we're going to the slide that says, what can I find in e-dockets? So you can find specific docket information like filings in a docket, the service list, the calendar of events or the schedule. You can see who the staff person is and their contact information. If there's a law judge assigned, who that is and their contact information. It's all there. You can query for a list of all open dockets. I don't recommend that, but you can do it. You can find tariff filing information there. That includes the filings, the effective date. You can create from e-dockets a list of all the pending tariffs that haven't been accepted, allowed, or approved. You can produce a list of all the upcoming scheduled events in dockets. And you can produce a list of all new initial or supplemental application type filings that were made within a certain time period. I use this feature. I have to say this is the one feature I use. If you call me and you ask me, hey, did that utility company make a filing last week about this certain thing? I will use that and I will look through all of last week's filings to see if it was filed. You can do the same thing. The advanced search feature provides specific company information or industry lists with links to company information. This is mostly used by the telco and water industries, has been my experience. And I'm not sure why they call it advanced search, because it's an odd little tool that's useful for very certain specific things. If you can't find anything, call us, email us. We can use our internal system to look things up a lot easier sometimes than what you can do in e-dockets. And it would be faster, it would save you a lot of time, and we're happy to help you. So we're going to pretend we're going to try to find a document. So on the e-dockets, select search type. If you know the docket number, you would click the button by docket number and enter in the docket number. And you have to remember to use the docket designation. That's the UEUMAR. You can do it with or without a space. Sometimes you get better results if you put a space between the docket designator and the number. And what comes up after that, go to the next one please, is the docket action screen. This is where you find all that general information I talked about, contacts. This is where you find your filings, and the description is just a very generic description of the document. You click on the PDF to actually see the document. Protected information, as long as you don't send it to us to post, is not posted out to e-dockets. If you find, I'm just going to say this here, if you find that you filed something and oops, it had protected information in it, call us right away. We will take down the posting and give you an opportunity to fix it. And you'll probably have to notify the service list, or we will notify the service list, because as soon as we post it, it's served. That's something to know. Next slide is finding due dates and event dates, and you click on your schedule tab. And I gave 2 slides to this because I wanted to show some dockets there's not a lot of information out there because there's not a lot of events going on. But this is where you find out about staff workshops. And in a bigger docket like a rate case, next slide, you would see all the filing dates, when the settlement conferences are set to be scheduled, and if it's about a rate case tariff filing, what the effective date of the filing is. Then we're going to talk about service lists from e-dockets, and there's a service list tab. The first thing I want to point out, because I get calls about this quite frequently, is only in contested cases, only parties show up on the service list. So if you've contacted us and asked to be an interested person, you will not see your name on this service list because only parties are shown. It's confusing, but it works.
Just a clarifying question, if you are an interested person, will you still get all the information?
And the question asked was, if you are an interested person, will you still get all the information? And the answer to that is, you will get everything that is filed through the filing center. So all the public information that's posted. The other feature of the service list is up above where you find your staff contact, is we have made it easy for you to email documents to the service list. If you're trying to contact the service list, this is not a filing, but you need to share with all the parties some information. You can click on the links up there to generate an email that's auto-populated. And I recommend that you do this each time you have that kind of instance, because that way service list changes are captured. If you're using an email from 2 weeks ago and just forwarding that on, you may miss some people who have changed their contact information, or you might be sending something to somebody who's no longer participating in the docket. It's just best to use the service list options. Next slide. Okay.
If you send something to the service list and then you get bounces back, we notify you, or how do we handle that?
So if you use the service list that's in e-dockets and you
Repeat
get
the
bounce
question,
backs.
please,
That's
from
what
the
I'm
audience.
doing.
Okay, sorry.
So if you use the service list function and you receive bounce backs, please let us know. You can just forward the bounce back to us at puc.hearings@state.or.us, and we will hopefully have more complete contact information and be able to reach out to the party and get that updated, corrected, removed, whatever the case may be. You can print service lists, and you ask, it's electronic filing. Why do I need to print a service list? Because for some filings, you are required to provide us with a certificate of service to show that you served the parties. For instance, in the case of protected information, we need to know that you served the people who were eligible to receive that information. And the protected parties are designated with either a C or an HC by their name on the service list. C is confidential and HC is highly confidential, so how it relates to protective orders, general protective order is C and modified protective order is HC. Because we used to call things different names and we didn't update the system because we were going to replace it. And we will, and it will be better. When you go to print a service list, if you've never done it before, my one caution is, up at the top of that screen, there's a print summary button. Once you hit that button, you need to deselect the docket actions and the docket schedule before you print your service list, or you're going to wind up with a whole bunch of information you don't want. Save yourself the time. When you look at the service list that prints, the people that have signed the general protective order have the whole word confidential after their name. Not everybody, and I'm going to say this here, not everybody who signs a protective order is on the service list. So don't be confused by that, because some people sign the protective order to participate in discovery, which is not part of what the hearings division does. It's not part of the official record. So I've had people call and say, but I signed the protective order. Why aren't I on the service list? And it's hard to explain sometimes, but it's only the people listed as the parties, and we limit that to 3, which I'll get into in the next presentation. We're going to move on now to service lists and how to be added. It's different for contested cases and hybrid cases with protective orders. You have to file a petition to intervene to be a party on a service list, and you are limited to 3 contacts, and that means 3 email addresses. We have people who try to list 3 people and 6 email addresses, so we will call and we will clarify which 3 email addresses you want on the service list. When we have our new dockets and discovery system, which we are working to get, we are hoping that that limitation will go away. But the current system that we have, it's a 20-plus-year-old system, and it does have limitations. I have a question.
I was just curious when you guys think that replacement may be coming.
The question is, when do we think the replacement will be coming? It's a hard question to answer. We have run into a lot of process that we need to go through, and the process is a lot slower than I ever anticipated. So I am hoping that we would at least be able to send out a request for purchase for a system sometime this year. I'm hoping the first half of this year, but I can't really nail it down at this time. Back to service list. One thing I want to point out is if you just want to monitor a docket, you don't want to participate, but you're really interested in what's going on, you do not have to ask to be an interested person. You can just do that through e-dockets. You can put a reminder on your calendar to check e-dockets for that docket every week on Thursday afternoon. But if you want to receive the email with the links to the filings, you can ask to be an interested person.
Is there any limit on interested persons that you can limit?
Okay, but the question is there any limit on interested persons? The answer is an organization is limited to 3 email addresses per service list. So you can't sneak around that 3 contact by saying, please list John, Joan, and Jane as parties, and then Peter, Paul want to be interested persons. We're going to say, you're limited to 3 email addresses. For rulemaking and non-contested cases, you do not need a petition to intervene. You send an email to our famous puc.hearings@state.or.us email address. You tell us who you are, what docket you want to be added to. You give us your complete contact information, please, and we will add you again. Each organization is limited to 3 contacts, except in rulemaking. In rulemaking, the way I say it is anybody can play. You can have 15 people on a rulemaking service list, if that's what it takes. But that's a lot to manage. I will put that clarifier out there. That's a lot to manage, not just for me, but for all of you as well. It's a lot easier if you keep it kind of same-o, same-o, same-o all the way along. Then you're not trying to think about all the different rules because you're acting consistently. But in rulemaking, anybody can participate. So I would never say no. I would just keep adding those names. How do you make a change once you're on a service list? If it's a contested case, you have to file a service list change through the filing center. You need to send us a letter saying, please add, please remove, please change out these people, because all the other parties need to know. So we need a filing. When you make a service list change in a contested case or a hybrid case with a protective order, make sure you look back at what you filed for signatory pages. And you also need to consider making filings to update that information as well. This is the only time I'm going to mention huddle because I don't want to talk about a huddle. It's not our thing, but it's important to do that so that the contacts in huddle are accurate for discovery. In rulemaking and non-contested docket cases, you just send us an email to make a service list change. Any questions? Yes?
There's something about being on a general list for natural gas or a general list for electricity. Can you talk about that?
We started with, the question is, there's something about being on a general notification list for electric or gas or telco or water. And those are called our general notification lists. To be placed on one of those, just send an email to us and say, I'd like to be on the general notification list for whatever industry. If you want to be on the rulemaking notification list for a certain industry, say that. And usually if you ask me, you send an email to us and say, I'd like to be put on the electric list, I will probably email you back and ask, do you also want to be on the list for rulemakings for that industry? Because I try to keep those lists as broad as we can. I figure more notice is better.
We have a question from the webinar. It says this from Candace Schatzfall. It says the slide, it states non-contested dockets are limited to 3 contacts. Isn't it contested dockets are limited to 3 contacts and non-contested are unlimited?
No, non-contested and contested are limited to 3 contacts. Rulemaking is the only exception.
My question is about changing staff. So we've changed the service list because maybe there's a new manager in the department, but how do we push that notification of change forward? And I know you don't want to talk about huddle, but oftentimes the old manager's name appears on those due requests, which is a tragic event.
So the question is, what if at your organization there's a change in staff? And the staff isn't necessarily on the service list, but is part of the discovery process. That's where I'm going to say, go back to looking at whether or not that person signed a protective order and make filings to correct that. Otherwise, if the person has not signed a protective order and they're part of the discovery, the electronic discovery process, you would send an email to Kay Barnes, who manages Huddle. Anything else? Okay, we're going on to my favorite topic, using the filing center. I'm glad we made it through e-dockets. I have to say, that's a relief. So first, who is the filing center? And I put this in here because it has changed over the years. The filing center for the past several years has been the Administrative Hearings Division Support Unit. So it's Candace, Cheryl, Kim, and me. We man it, we split up days sometimes for report type filings or just random filings that we get. But we try to process our own filings. So if you make a rulemaking filing Tuesday through Friday, I'm probably going to process it. If you make a filing in a case where Cheryl is support for the administrative law judge, she will most likely process it. But we do back each other up, and if we're away or buried with other tasks, we will help each other out. If you have a question about making a filing, we want you to call us or email us. We would rather answer 100 questions and have you do your filing correctly than to have you struggle on your own, make a filing that we can't process. So we love questions. We're happy to answer them. I wanted to put it on this slide over and over and over and over and over, but my coworkers said not to. So when else do you call us? If you're planning to make a filing after 4 p.m., we would like to know that ahead of time. It gives us time to plan for that because filing center isn't the only thing that we do. And if we're stuck on a big project that has to go out that day and everybody waits till 4:44 to file, it can be really hard for us to get all that done. If you're having technical difficulties, or if we're having technical difficulties. Either way, if you can't get a filing to go through, call us. Let us know, especially if it's something that's due that day. It's testimony due this day. Because then we can make sure that we communicate with the administrative law judge that there are technical difficulties going on here. And then the schedule can be adjusted accordingly. That's really important. If you can't get a filing to go through, you need to let us know. So we thought you might want to know what happens after you send your email to the filing center with your attachments. Because I know some people think you send it, we click a button and boom, there it is. It's not quite that easy. So we look at a bunch of things. We look at the file name format of your filing and the size of your attachments. Because if your file name isn't formatted correctly, or it has special characters in it, our system just can't process it. It doesn't know what to do with it. If your filings are over 10 megabytes, it's going to take us a while to use a big hammer to pound that round peg into that square hole. It takes some time. We look at the number of pleadings attached because our rules say it's one pleading per filing with the filing center. We look for appropriate labeling of testimony and exhibits, which we'll talk about at the end. We look for signatures on pleadings and comments, and this is a big one. We look to see if the filing is labeled as confidential or protected. If we see that as we're scanning through your 125 pages and we happen to catch that the top of a page is labeled as confidential, we're going to call you. Is your filing out of time? Are you trying to file testimony after the due date? Are you trying to file briefs at a time? We're going to look at that. And we're going to look to see if the service requirements are met in those few situations where you are required to serve the parties and provide us with a certificate of service. After we check all that, we process your filing. This is what our screen looks like in the filing center. The subject line of the email that you sent to the filing center goes in our description box, and what we put in the description box is what you see as the description of the document in eDockets. So if you have a really good subject line for your filing, we have a lot less work to do. And it goes faster. You will also notice what you don't see is whatever you said in your email, because your email is not part of what goes into the filing center. That I will call people and I will say, I see in your email to the filing center you said this, this, and this. If you need everybody else in the docket to know that, you probably need to send a cover letter for that filing or something so we can put it together for you. Sometimes I will ask you, may I include your email with your filing? Because I know that information is important, but I won't do that. We won't do that without calling you first. So the other thing you'll notice on what we see in the filing center is that file names are only about 55 characters. So if you start your file name with the same 55 characters and you have attached 4 files, we can't really see what the order of those files are supposed to be. It It's nice. I know everybody has their own naming conventions, but in that case, if you all of a sudden you see your file names are, 60 characters long and it's the same 55 characters at first, could you put a 1, 2, 3, 4 for us to get those documents in order? It would just help and it goes faster. Our next slide is one action per filing. So my example is always the filing of a stipulation and testimony supporting the stipulation and a motion to admit the stipulation. Those are 3 separate filings. It's not just a stipulation filing. Those are 3 separate filings. We really need you to send the motion in one email, the stipulation in another email, and the testimony in a 3rd, 4th, and 5th email, depending on the size. And if you think about what you see in e-dockets, it helps you to remember this. Because in e-dockets, you can sort by the type of filing. And if you're looking for the motion to admit the stipulation, you're going to sort by type and scroll down to motions. Then if you want to just see the stipulation, you're going to use that sort and look for stipulations. And if you want to see the supporting testimonies, what most people want to see, you're going to sort again by the type, and you're going to be looking for testimony. If you're trying to cram 3 different types of filings into one filing, your ability to find it in e-dockets is going to be very, very limited. Now I'm going back to my time of day to file speech. But this is really important. The Filing Center, yes, is open from 8 to 5. If you plan to make filings, especially big filings after 4, please call us and let us know. Again, I'm going to bring up technical difficulties as soon as you know you're having problems or we're having problems, because sometimes we don't know that there's a problem with our system. If you call us and let us know that there's technical difficulties and you don't think it's your end, we will work on our end to find out right away and get that fixed. But we need to know. We need for you to contact us. If a docket has a lot of parties and the due date is today, and everyone tries to file between 4:30 and 5, our antiquated system has a higher risk of crashing. It's just the age of the system that we use. If we ask it to do too much all at once, it fights back. And then everybody's frustrated. The other important part about filing earlier in the day, if you think back to the beginning of this part, we talked about all the things we check for. If there's something wrong with your filing so that we would need to decline it, if you wait until 4:59 to file it, you submit it, you run out the door, we look at it and we go, oh look, it's not signed. We try to call you, you're gone. Your filing is declined. That's why we want to know you're filing something. And it's to your advantage to file early as possible. I understand. Some of these deadlines in these cases, everybody's working on everything and nobody's going to get it done till 4 o'clock. We understand that too. But call us so that we can be ready for it and help you, because that's what our job is, to help you. I have a question.
Yeah, it's a bit of a comment slash question. Mike, something that we've done in the past, and I wanted to make sure that it was an okay practice, but sometimes there's a filing deadline or multiple parties in the parties are all filing a piece of testimony or comments at the same time. And, there can be like a strategic reason for wanting to file as close to 5 as possible, so that attorneys don't have an opportunity to read your filing, and then, say you file at noon, and then they're not gonna file till 5, they have 5 hours to kind of change their arguments based on what they filed. This is something that we've done in the past to try to be cognizant of the workload on the back end, is submit something earlier in the day and say, hey, could you please hold on to this and wait to file it until 5, but here it is ready. And I guess I was curious if that is an okay practice, or what you would advise this?
So the question, I won't be able to repeat the whole thing, deals with strategy of filing. And that is, if a party makes its filing at noon, other parties have an additional 4 or 5 hours to recraft their filing, and it's an unfair advantage. So the question is, could we send our filing to the filing center and ask you to not post it until 4:50 or 5 minutes to 5? I would like to say, yeah, we'd love to do that for you, but I can't guarantee that I won't walk in, see something in the filing center, and process it. Because we don't always cross paths in the filing center. We can be going in and out of meetings and in and out of doors, and our job is to try to process those filings within an hour of receiving them, generally speaking. We aim for 20 minutes, but it's usually within the hour. So I would hesitate on that.
Yeah, we'll say that once we have a new system, we might be able to accommodate those requests more readily. So.
Well, with a new system, you'll be uploading filings yourself. Or that's my vision. So then it would work. But with our current system, I would say it's a risky request. Another question?
Oftentimes when we file, our actual document has 3 pieces, maybe a cover letter, something in the middle, and maybe a certificate of service or some other end piece. Is it preferable if we PDF it all together, or if we send a cover letter, the middle, and the end as 3 separate documents?
So the question is, a filing consists of a cover letter, a middle piece, and an end piece. Is it preferable to send it all as one PDF or as 3 separate documents? It depends on the size of the documents, honestly, because we do have our 10 megabyte limit for email. Our system combines them. If you send us one PDF, it processes faster because it's not thinking.
Diane, I thought that the size limit was 20.
We have 2 different size limits depending on what process. Sometimes our email system will accept 20 and our docket system will accept 10. Depending on, our email system is part of a state system. Sometimes you can't get email through that's more than 10 megabytes. So break it down as easy as you know, and see what works is usually what I tell people. If it's not coming through at 20, break it down to 10. And then what we have to do on our end is we have to recombine things and then do the reduced PDF size until we can get it to a size that the system will take.
As you can probably tell, we're very excited to get a new system.
I'm going to go to the next slide about why was my filing declined, and I'm going to whip right through this one because there's the top 5 reasons. No signature, improper labeling of testimony and exhibits, your document was sent in a format that can't be accepted by our system or processed by our system. We can't work with JPEGs. Pretty much we're text searchable PDF or Microsoft Office products. There's no certificate of service when one was required, or the filing doesn't fit the type of proceeding, which would be, for example, a petition to intervene in a rulemaking. I would still add you to the service list, but I will decline your filing. And lastly, we're going to talk about labeling testimony and exhibits. And I asked Cheryl to do this because she works a lot with consumer complainants who have to file testimony and exhibits. And when I listen to her tell this over the phone, she does it the best of any of us.
Thank you. So it's just a few things to remember when you're going to file testimony and exhibits. You want to make sure that the party name and the exhibit number is also with a witness last name and page number in the upper right-hand corner, and then it's paginated correctly. The exhibit numbers must be consecutively numbered for each witness or set of witness. So say you have staff and exhibit number 100, Walker, page 1. If I had more exhibits to go with that testimony, then it would be staff exhibit number 101, Walker, page 1, and that would continue for each witness that you're submitting testimony for. Each round of testimony, you would pick up with the next consecutive exhibit number. So the next round, the testimony that would be due, it would be staff 200, Walker, page 1, and etc. The only other item that you need to be careful of is if you submit testimony that does have confidential information, you need to file a redacted version and send your confidential portion labeled pursuant to the protective order that's guiding your filing. And it must be contained in a separate envelope labeled with the legend as set forth in the protective order inside the mailing label. Because the filing center, we receive our mail from our mail room, they open up the general envelope and bring it over. So we don't want any papers accidentally spilling out anywhere. So I'm open for questions if you have any.
Go ahead.
Is there any certain format or format size that you guys require? Times New Roman or Arial or whatever it may be?
The font, I don't believe we have any requirement for a font. The font size, no less than 12. We all need to read it. But it's important to make sure that you have your series consecutively numbered so that by the end of the docket, you're not trying to file something and you're starting over with the same witness with the same series number. It gets out of whack that way. And it is really confusing, and that we would call you and ask you to correct it and resend. Yes?
Question for Diane, actually, referring to an email that I sent you. I forecasting natural gas, but I had submitted a tariff revision that we do every year, and I put a report cover sheet on the top of that, and basically notified, no, that's not for tariff revisions, that's for annual reports. So when you can speak a little bit more to when to use a cover sheet, and then I had also attached some spreadsheets I just needed staff to see. It wasn't a part of the public filing post in the docket. It was just, kind of backup for staff. Explain a little bit about sort of how you navigate some of that. Looks like we worked through this, but those were a couple issues I saw, and I could see them coming up again too. But.
So the question is when to use an e-filing cover sheet, basically, and what to do with what I'm going to call staff work papers. The answer to that is the e-filing cover sheet is generally used for report type filings, whether they're quarterly, monthly, annual. That helps us figure out which report docket those go in. That was their intended purpose. And as far as staff work papers, there's a separate email address that I don't have written down in front of me, but I can provide it to people by email afterwards. But it's something along the line of puc.workpapers@state.or.us. And you can tell us in your email to the filing center that you're sending work papers to that. That email, the things that go to the staff work papers address do not come to the hearings division. But if you tell me in your cover email that you've sent work papers, I can make sure the people on the third floor are looking for them, and I can tell them what docket they're going with or what tariff filing they belong with.
So I have a question that I maybe should have asked in the beginning of this presentation, but if I am brand new to something on e-dockets, where would I look to see if the docket is contested or not contested? And is there a notification process that the not contested docket switches?
So the question is, how do I know what is a contested docket or a not contested docket? And is there a notification if it switches from a not contested docket to a contested docket? The answer to the second question is yes. We will send out a communication that says this docket is now following contested case processes with the appropriate language in there.
I can take the rest of that question. So we have a new best practice. So when the very first time in a docket wherein ALJ makes any type of ruling or communication in the docket, they will include some paragraph which will designate the case. So you'll want to look for that first communication, the first filing in the docket. And the ALJ will also notify all parties in a filing if a case switches over. So sometimes that happens after a contested case. Occasionally we'll go into a compliance phase that will not be contested. That'll be notified. So. All right. Well, I think we're out of time. I want to thank everybody for attending, and specifically I want to thank Diane and Cheryl and Candace and Kim and Chris and Al for all the hard work they put into this training. And then we'll take a couple minutes and we'll hear from the commissioners, and they'd like to say a few words. So.
First, I'd like to invite a round of applause for the team that put this together. I'm Megan Decker. I'm the commission chair, and I have a couple friends with me to help thank you for attending today, Commissioner Letha Tawney and Commissioner Mark Thompson. The reason that we're here to thank you for being here today is because process is the lifeblood of the Public Utility Commission. It's what gives our decision making the integrity and confidence that people have come to expect. I started my career in energy as a new employee of an advocacy group, and I was responsible for our advocacy before public utility commissions. So I know firsthand how intimidating it can be to come into a PUC environment and try to figure out how to operate and navigate successfully. So I know there are lots more people, maybe even than when I got started, interested in what we're doing and trying to play a role. So for that reason, I just really want to thank our Administrative Hearings Division for taking the time to put this together and help people both with established organizations and people that may be new to the process understand a little bit better who we are. I particularly love the face-to-face connection because I remember being so intimidated to just call up the filing center and ask a question. And if I had only known that it was these people here, I might have felt better about it.